I just want to welcome everybody to the North Jersey Civil War Roundtable. Let me just give a uh, brief commercial for our roundtable. We're a large roundtable, and I think we're the largest in New Jersey. What we're noted for is the quality of our speakers and our programs, and like you say, a wide variety of interested people. Our meetings used to be live, but what happened when COVID came, people just weren't coming out to the meetings. And we started to offer our programs onto Zoom. And as a result, we picked up 11 members, people from 11 states. And in addition, we have Barry Crompton, who's on from Australia, who's one of our members. So far from being a local organization, we've now became a national organization. We no longer have live meetings, and we are strictly on Zoom. What we're noted for is we already had two Pulitzer Prize winners, James McPherson, Eric Foner, and we would have had a third Pulitzer Prize winner, Edward Larson, but COVID struck on that one. Some of the names that appeared before our roundtable James Bud Robertson, the definitive biographer of Stonewall Jackson, Craig Simons, Michael Burlingame, who's the outstanding Lincoln scholar, uh, Thomas Fleming, and then we have our own New Jersey historian. His name was John T. Cunningham, who was our member. Things we do with our organization: one, we are on the color bearer level of the battle. It used to be Civil War Trust, now it's Battlefield Trust, and hopefully we'll go up one more notch on that. We meet the fourth Thursday on every month. We're offering our program to the various libraries who are carrying our program. They list it on their calendar, and it's like PBS. Um, you could sign up with the library; it will send you the link, or the alternative, you could sign up with us. If you'd like to become a member, our dues are $39, and it helps support our programs. And is why $39? Because you'll remember paying $40. Everybody says, "Oh no, I paid $40." So it's 39. It's $39. Um, we also had, for a period of time, we had our own book award. Maybe we'll resume it next year, but one of our women was Louis Mazer, and then we had Andrew Del Banco, who won it for The War Before the War, which is uh, uh, one of the important books. And if you ever read a book, I'd recommend short of that. We have we support. Oh, this is interesting, guys. Throughout the country, it's called History Day. Every year, over 500,000 students participate in a history competition. They go as juniors, they go as seniors, they go as individual and group. And every year is a topic. And they could either do a paper, they could do a performance act, a website, a documentary, or the exhibits you always see throughout. Then the winners of that competition go on to the University of Maryland. The reason I bring up the History Day, how important it uh, is each of the students, the bright students, they have to do a position paper, they have to do research, um, and it's not like to apply to a college. This is important as opposed to serve coffee at a PTA meeting. And I always brag. One of our members, I met her a number of years ago. She won an award, and I met her at Hyde Park, Franklin D. Roosevelt's home, and she recognized me. And I said, "Allison, how did you do?" She went to the finals. University of Maryland saw what she did, gave her a 4-year scholarship. And we had another student who was an honor student at Princeton. Another one was an honor student in Yale. So the competition is nationwide. And one thing I'd like to carry out of that, find out if your state does it. And what happens is we give awards to one of the great New Jersey historians, John T. Cunningham, um, and also it's great publicity for us because we appear on the website as giving an award through that. So you really may want to consider. The other thing we do have is a members only book group, and John Harper is on tonight. He prepared at the time he was prepared an extensive list of questions, and it wasn't the book of the month. We went as far as we can into our discussions of the book, and I think Eric Graverman will agree with that. You know, the quality of the discussions that we have in the room. John Sullivan's also another member, and so is Barry Crompton.
Your discussions are a greatest taste of Civil War insights.
Thank you. But in any event, that's a meeting. Now, okay, that was the commercial. About 20 years ago, Judge John Harper had a number of our members who were attorneys. They decided to do a legal presentation, a legal program of Civil War cases, and he brought in quite a number of attorneys, a number of judges. For a long time, we've had mostly our attorneys who are members do this, but then over the years, we have other people, other attorneys and judges come in and also do a presentation. The caliber, the quality of the program, this is not my brother-in-law had a musket program. This is these are in-depth programs at a higher level through this. 2 years ago, Jay Maloney, who's doing a program today, his program was accepted it became a continuing legal education program. It was offered. So that's the caliber, the quality of the program that we have here. And I think that's the importance of the program that you'll see. And for those of you, for other roundtables existing, it becomes a great thing if you get your attorneys involved in this. We had one program devoted to the 13th Amendment, another to the 14th Amendment, another 15th Amendment, another I'm just trying to think of the cases. We do the Dred Scott decision, which took a whole program. So you may want to consider getting your attorneys involved in doing a program. And again, it becomes on a high quality. It takes work. It's not something you're winging. You'll see the extensive work of Jay Maloney. Now, okay. Let me explain who Jay Maloney is. John C. Maloney is of counsel in the law firm of Traflet and Fabian in Morristown in New York City, where he's a trial attorney and complex commercial litigator. His practices focuses on commercial disputes, pharmaceutical litigation, class actions, and international arbitrations. Prior to joining Traflet and Fabian, Mr. Maloney was a partner for many years at Pitney. He served for 8 years as chair of the New York State Bar Association Committee on the Federal Constitution and Federal Litigation. A graduate of Fordham, he earned his MA in American History at Columbia University and his JD from NYU School of Law. He was business editor of the Law Review. Prior to private practice, Mr. Maloney served as law clerk to the Honorable John J. Gibbons, United States Court of Appeals for Third Circuit. He served for 28 years in the United States Army Reserve in the military intelligence, where he earned the rank of colonel. I got to digress 2 seconds. Every year we honor our members. I send out an email recognizing the people in our organization who served in the military service. And this year we had 15 members that were listed. Okay, now go back again. This will be his 20th legal presentation for our roundtable. Jay, you're on.
Thank you, Rich. Let me bring up just the slides, if I might. Abigail, everybody can read that?
Yes, looks good.
Okay, let me go to the top and, okay. Well, good evening, everybody. It's a pleasure to speak with you again. This is our annual legal presentation, as Rich mentioned. The legal presentation is based on the assumption that the issues arising out of Civil War and Reconstruction were fought out not only on the battlefields, but also in the legislatures and courtrooms throughout the North and South. Earlier presentations, as Rich has mentioned, included in-depth studies of the 13th, 14th, and 15th Amendments, impeachment of Andrew Johnson, and last year we examined the concept of secession and the failure to bring treason trials against Robert E. Lee and Jefferson Davis. Tonight, I'd like to focus on President Grant and his war against the Ku Klux Klan during the 1870 to 1872 period. We want to look at the political and legal environment in which these events occurred, the legal and in some instances the extra-legal tools that President Grant used, the results of Grant's war against the Ku Klux Klan, and then we want to ask ourselves the question, what does this episode reveal about the Reconstruction period? What lessons can we learn? Now, President Grant, during this period, had enemies, obviously, in the South, the enemies of Reconstruction. And at the same time, and later, he had enemies with Northern politicians who were seduced by the visions of post-war conciliation with the South. So the first thing we want to do is just to make sure we're all familiar with kind of the context in which President Grant's war against the Ku Klux Klan arose. Civil War ends, but there's no peace treaty. There's no standards that are set for readmission of the states that had previously seceded. What was necessary for reconciliation? The goalposts for what was going to be required were moved several times by the president, by Congress. At the same time, we have a military occupation of the South by federal troops. The South, in most respects, was treated as if they were conquered provinces. Local and state governments were not functioning. Because there was no peace treaty, there was no Truth and Reconciliation Commission, the concept of wartime, that is, military control of civilian government, remained in effect. The immediate effect of the Civil War, of course, was that 4 million former slaves were freed. This meant there was no labor system in the South at all. By the end of the Civil War, $4 billion in wealth measured in 1860 dollars was completely lost. Now, there were many, many open questions that Reconstruction was supposed to resolve. Who would rule? Whites, blacks, the army, the federal government? Would Black Americans be permitted to live as citizens in fact, not just in name? Would they be permitted to hold office, testify in court, and enjoy social equality with whites? Would former Confederates be willing to cooperate with them to rebuild the South, and on what terms? Could the races live together harmoniously and grow prosperously? And how long would white Northerners support the military rule in the South, which they disliked and did not want to fund? Well, take a view of an ordinary citizen as of 1860. What was his or her experience with the national government? Well, it was very little. The federal government was responsible for delivering the mail. Federal government was responsible for collection of tariffs, port duties, and as we heard from Professor Del Bianco a few years ago, thanks to the fugitive slave law insisted upon by the South in 1850, Northerners were treated to participate in slave catching in the North, and that was viewed as a federal action. Or what about 1865? What would that same citizen see? Well, first of all, the citizen would recognize that he could be drafted into the army, that the national government could tax his income. National government built the railroad system and the telegraph system, homesteading. And most importantly, for many states, the federal government was borrowing substantial sums of money in order to pay off contractors and support the war. Now we had government legislation in banking. Particularly from the Republican point of view, the concept of state sovereignty had changed dramatically as a result of the Civil War. And the South was very much opposed to that. What about the legislative environment? We've previously discussed, and everybody's aware of the war between the president and Congress over who is going to conduct and be responsible for Reconstruction. We had President Johnson's plan for Reconstruction, followed by the radical Republicans, who decided that the military was going to enforce Reconstruction. The Congress also passed the Freedmen's Bureau Act in 1866 that set up a social welfare agency for the freedmen. It also passed the first major civil rights legislation in 1866, saying that everyone who was born in the United States could be a citizen with certain rights, to enter into contracts, and to enjoy equal benefits in society. And probably the legislature, the federal legislature, had reached what I would call the high watermark of idealism for multinational democracy, particularly in the 13th, 14th, and 15th Amendments, which they passed. Professor Foner has said that the 13th, 14th, and 15th Amendments really constituted a second founding of the Republic. 13th obviously removed slavery, outlawed slavery. The 14th created a concept of national citizenship and introduced everyone to the concepts of privileges and immunities of citizens, as well as due process and equal protection under the law. And the 15th gave the black man the right to vote. Now, obviously, these were statements of high idealism, but each amendment included a provision where Congress could introduce legislation to enforce the amendment. And that's what it really did. However, it was the 15th Amendment among the three that probably had the greatest impact on the South in an immediate sense. And what do I mean by that? Well, suddenly, former slaves were now, the males at least, were allowed to vote and hold office. That meant that they could exercise political power. And in certain areas of the South, particularly South Carolina, Louisiana, Mississippi, and parts of Georgia, the black population exceeded that of the white population. And so they were going to dominate the political power. This triggered enormous concerns about white supremacy in the South. In the North, some mixed reaction, including those who believed that we've done enough. We don't want to make the black man the ward of the state. Individuals like William Lloyd Garrison said, we've finished the struggle for the black man with the passage of the 15th Amendment. James Garfield, Speaker of the House and later President, concluded the same, that the 15th Amendment gave the blacks the right to vote. From here on in, they were on their own. The most immediate reaction to the 15th Amendment and the exercise of political power in the South came in the formation of the Ku Klux Klan. Some point in 1865, in Pulaski, Tennessee, a group that started off as a veterans fraternity initiated the Ku Klux Klan. At its peak, probably in 1871 to 72, 300,000 members of the Klan existed. In many respects, they were the de facto wing of the Democratic Party in the South. Let's do a little bit of profiling of who was in the Klan and what were their objectives. Well, their objectives were to wage a systematic war of terror against the blacks who were voting and Southern Republicans who were assisting them and voting. Terror was at the core of what the Ku Klux Klan was doing. Their main targets were the most able, the best educated, and the most assertive blacks and their Southern Republican colleagues. They wanted to scare the blacks and the Southern Republicans from voting. And so they engaged in lynchings, murders, assaults. There was also a degree of sexual perversity where they engaged in castrations and rapes. Their whole point was to create a reign of terror and make sure that blacks and Southern Republicans did not vote. Well, who made up the Ku Klux Klan? They weren't the ruffians. They, in fact, were leading men in the community: doctors, lawyers, churchmen, journalists, angry war veterans, former slave owners, those who had lost all that wealth that we just talked about. The structure, it was very hierarchical. They had local commanders. The groups were able to operate across county lines. In terms of leadership, their main leader was Nathan Bedford Forrest, the former general in the South, who became the Grand Wizard of the Invisible Empire. He was assisted by John Gordon, also a general in the Confederacy. These individuals taught the Klan how to organize and how to wage guerrilla warfare. That was part of the military structure. They, in general, attacked at night. They rode horses. And the military, who was the police force, were primarily infantry and were unwilling to really combat what the Klan was doing. Now, the Klan had oaths of secrecy. They dressed in these white gowns to remain anonymous. The white gowns were engaged in spooking the African Americans by the Klan claiming that they were the souls of the former Confederate dead. So let's consider a situation such as a school teacher in Columbus, Georgia, Republican, teaching a number of black children. And the Ku Klux Klan attacks the schoolhouse and burns it down. What is that teacher to do? Well, you'd say, well, you'd complain to the local government officials, the sheriff. They would do nothing. Who would testify? There would be threats against the teachers that if they move forward with any prosecution, that more punishment would be delivered. The entire system, local government, law enforcement, was corrupt and paralyzed. Nobody prosecuted anything. The whole point of the Klan was to subvert the trust in the government. So, many of the local officials and the blacks wrote to the local governors and to President Grant, who read these reports and was concerned about the lawless chaos that existed in the South and the fact that this group was an organized group of terrorists. But what could he do? Well, a couple of things occurred. Number one, the Department of Justice at this point was formed in March of 1870. Prior to this, it had been under the Secretary of the Interior. It wasn't a full-time job to be Attorney General. If the government needed lawyers, they would hire private lawyers. So beginning in March of 1870, we now have a Department of Justice with responsibility for enforcement of civil rights laws. We have one individual by the name of Ackerman, Amos Ackerman, who was the Attorney General, who Grant made sure was going to look into the situation of the Ku Klux Klan in the South. Well, what was Congress doing? Well, Congress had grown accustomed to these massive joint investigations, as we saw during the conduct of the Civil War. Here, they formed a special select committee to inquire into the conditions of the affairs of the insurrectionary states, and in particular, the Ku Klux Klan. For 6 months, they held hearings, not just in Washington, but they traveled throughout the South. They compiled a 13-volume report consisting of 8,000 pages where they interviewed witnesses, they interviewed Klan members, and it reached a damning conclusion that across the South, there was no security of law and property, that there was no local authority. So what did Congress do? Well, it passed a number of acts, including what has been come to be called the Enforcement Acts. And these Enforcement Acts made federal offenses out of conspiracies to interrupt or prevent somebody from voting, and also prevented state officials from acting under the color of state law to interfere with one's civil rights. They also made these offenses federal criminal offenses, and they were going to prosecute them in federal court. So now you start to see a federal judicial system fill the vacuum that existed in the South, with prosecutors directly from the Department of Justice or from the U.S. attorneys. So that is a very positive development. And Grant says, okay, now that I have this authority, how should I approach the Klan? Well, the Third Enforcement Act, which has been called the Ku Klux Klan Act, gave the president the power to suspend the writ of habeas corpus. And that's what Grant did in 1870. The suspension was for 9 counties in South Carolina and was going to be for a period of up to 2 years. And so what happened was that Grant, and he used the military, and in particular, he used the 7th Cavalry, which took care of the problem of how the Ku Klux Klan operated, using horses and being able to escape federal troops. And they arrested close to 3,500 Klansmen from the get-go. This effectively broke the back of the Klan, or at least that's the claim that is made, because the Klan, in response to this force either left town, went to Canada, they stopped the violence, and they went back under the rocks from which they came. So Grant was viewed as somewhat of a hero for having taken this action and broken the authority of the Ku Klux Klan, and hopefully to permit blacks to vote. But of course, that's not the entire story. In many respects, and this is the history of Reconstruction, the North had a dramatic loss of political will to enforce the civil rights for the freed blacks. Democratic power continued to increase, and the Democrats, and this was very true of certain splits in the Republicans, were somewhat angry at Grant for his authoritarian tactics. They didn't like military occupation to begin with. They were very concerned about the use of the military acting as a domestic police force. And as I said, many of them thought, well, you know, this was really up to the blacks to take care of their own problems and not to have this constant interaction funded by the North to protect the blacks. So what happened? Well, a couple of things. The martial law that Grant declared, as I mentioned, was really partial. It wasn't full martial law as existed during the Civil War. There were no military tribunals that were used, and we're going to get into that when we discuss the cases, but just keep in mind that, at least from my perspective, Grant and Congress did not use the full panoply of powers they had at their disposal. Many of the cases that were brought by the Justice Department, more than half, resulted in convictions or dismissals. The other half, the people were let go. The punishments were not severe. And why was that? Well, what they were being tried for was not lynchings and assaults and killings and rapes, but rather the deprivation of federal rights. They still had a problem because they were trying cases in federal courts and witnesses were reluctant to testify. So not that many convictions occurred at all. Then we have the other issue that comes up, which is, well, what more could have been done? And the states, particularly in the South, and from beginning with Tennessee and others, the state governments were being turned over to, upon readmission, to not Southern Republicans, but so-called Southern Democrats who were viewed as redeemers. And part of what happened was that these redeemers who took over the state governments or enacted Jim Crow laws, which prohibited blacks from voting or acting like other white citizens, not protecting them at all. So in many respects, even though the Klan wasn't using violence, the effect upon the black population was the same, because now the local government that was restored wasn't giving them much in the way of protection. And so instead of terrorism, we had intimidation by the Jim Crow laws. Now, one of the things to keep in mind is the political environment. And as I mentioned, there was an increasing Democratic popularity. In fact, they took over the U.S. Congress in 1874. In 1872, in the election for president, Grant ran, and he ran against Horace Greeley, who was a member of the so-called liberal Republican Party, which was in effect established by former abolitionists such as Carl Schurz from Missouri and Lyman Trumbull, Lincoln's friend, from Illinois. Both Trumbull and Schurz took the position that what Grant did in his war against the Klan, they could not abide by, that it was too authoritarian, too militaristic. This was anti-Americans. And so that split the party. There were other issues, to be sure, in terms of public corruption and the reforms of the civil service system. But the treatment of the South was among the more important issues. And finally was the economic conditions. There was a panic in 1893 brought on by speculation in railroad bonds and banking irregularities, but in many respects, it became what they called the Long Depression. And people of the North did not want to continue funding the military occupation in the South. Now, if you wanted to say to yourself, what were the changes in public attitudes? Because it was dramatic. We went from highly idealistic 13th, 14th, and 15th Amendments, Reconstruction as an experiment in a multiracial democracy, and now the North is turning its back. It's saying to the South, do what you want. It's up to the blacks if they can get it together to protect themselves. We're no longer going to do it. Well, you might want to look at some of the Supreme Court cases that came down, which were interpreting the 13th, 14th, and 15th Amendments. And I have a list of them, and I think I'll go through a couple of them. I don't want to talk about Milligan right now. I'm going to save that for the end because that I think is a very important decision. But you have decisions like the slaughterhouse cases in which it did not involve blacks at all. What happened was in New Orleans, the Louisiana statute decided, the Louisiana legislature decided to create a monopoly in regards to a slaughterhouse. And doing so, it put thousands of local slaughterhouses out of business. And Louisiana said, we're able to pass this statute, create this monopoly, because we can exercise the police power to act to protect the public health and welfare. Well, the owners who had lost their businesses sued the state, claimed that, well, we had a right to a profession that had been taken away by the state. And this was a denial of due process. The Supreme Court, in its decision, said the 14th Amendment was really designed to protect blacks, not engage in this kind of local regulation and preventing states from acting using their police powers. And so in the slaughterhouse cases, in effect, the Supreme Court was putting the brakes on what could have been a very expansive reading of new citizens' rights. The United States v. Cruikshank is interesting because it grew out of a riot and in Louisiana in 1873, in which several blacks were killed. And the court used it as an opportunity to say, yes, when state officials were sued for taking no action, that yes, they were subject to the, in this case, the 14th Amendment, because they didn't act to protect rights of the Black victims, but they found technical problems with how the indictment was written, and that it didn't specifically mention race as the motivation. And the court was emphatic that these crimes should have been state crimes, not federal issues. Again, instead of being charged with killing, the local officials were charged with interference with federal due process rights. And the court said, we don't think the Reconstruction amendments really included that. Civil rights cases. In 1875, Congress passed the Civil Rights Act of 1875, which was probably the broadest possible statement of civil rights for Blacks in the country. And it focused on the right to public accommodations, to transportation facilities, and the like. And the civil rights cases turn out to be a compilation of about 7 different cases brought by private Blacks against private transportation and hotel companies. And in that case, the Supreme Court held the amendments that had been passed, the Reconstruction amendments, were meant only to prevent state action, not private action. And so the hotels, the transportation companies, they can discriminate because they're private and they have a right to do so. But they can't say that that is a purpose of the Reconstruction Amendment. Now, you may say to me, well, is that still the law? Well, the answer is no. In 1964, the new Civil Rights Act was entered that was addressing racial discrimination in public accommodations. And that also went before the Supreme Court. And the Supreme Court said, well, we're not going to reverse what the Reconstruction Supreme Court said in the civil rights cases. But what we will say is that Congress had the right to outlaw private discrimination that involved race on the basis of the Commerce Clause, the interference affecting of state commerce, not the Reconstruction amendments. And finally, just this one last case, Plessy v. Ferguson, 1896, the Jim Crow system of law that I talked about that was enacted by these Redeemer governments decided that they could justify their discrimination by it being separate, even though it was equal to what the white citizens could enjoy. And so in this case, out of Louisiana, it had to do with the right of Mr. Plessy to ride on a particular streetcar in a particular car that was for whites only. In an 8-1 decision, the Plessy court held that separate but equal did not violate the 14th Amendment. Interesting to note that the one dissenter was Justice Harlan, who had been a slaveholder and who predicted, in his opinion, that Plessy v. Ferguson would be as notorious as the Dred Scott decision. And of course, he turned out to be right, because the Brown v. Board of Education decision in 1954 reversed Plessy v. Ferguson, holding that separate is inherently unequal. But let me go to Ex parte Milligan, which is one of my favorite cases. And I know we discussed it with Professor Lurie back in June because so many of the Lincoln appointees were on the court. Now, Ex parte Milligan held that you cannot have military tribunals try American citizens if the American courts or the state or federal courts are open and available. What happened in Milligan was that Milligan was a rebel living in Indiana, and he and a group of his compatriots decided they were going to raid the armory and they were going to interfere with the draft. They were arrested by the local military officers. They were tried before a military commission and sentenced to be hanged. Now, what's interesting is, what do we mean by a military commission? This is not the same as trials within the military itself, which is governed by the Uniform Code of Military Justice. A military commission is appointed by the president or Congress. It's a group of officers who serve as judges to try cases involving non-military citizens, so to speak. Now, they don't have the same procedures and protections that you have in a court. For example, there's no jury. There is no requirement that the verdict be unanimous, just a majority. It has to be 2/3 if there's a capital offense. What's interesting about Milligan is the timing for its decision. I mean, this is 1866. The Civil War, certainly in the North, is over. What is the Supreme Court doing? Well, the Supreme Court in 1866 is addressing a Reconstruction audience. This was meant to tell the Congress and the president what kind of justice could be meted out to the South. And as I mentioned about Grant and his war against the Ku Klux Klan, he didn't use military commissions. Now, what difference did it make? Well, here's the difference. Yes, he had the right of habeas corpus, which came right out of the Abraham Lincoln playbook during the Civil War. And he could hold people indefinitely in detention. In the Civil War, of course, with the military commissions, there was thousands, they estimate it's about 13 to 15, tried before these military commissions. There were verdicts. Now, what the Milligan court was saying to the Reconstruction period, president and Congress, you can't use military commissions. And so what happened? Well, as I mentioned before, the results of Grant's war on the Klan, even though they had a new Department of Justice and they had federal trials, is a mixed blessing because there weren't that many convictions. The federal system was inundated. They couldn't handle all of the arrests of all of the Klan members. Now, that is something to consider because military commissions have always been controversial. They don't seem to be available, they don't seem to be supported by those who believe in due process and equal justice. How effective they are? They certainly were effective during the Civil War. Many consider it a blot on Lincoln and Stanton's record. And so there's concern that those kinds of tools exist, and maybe they need to be used in emergency circumstances, but they weren't used in the situation that Grant faced. And as to the Ku Klux Klan is like a game of whack-a-mole. It came back in the 1920s. It came back in the 1950s with David Duke, and many claim it came back for Charlottesville just recently. So the Klan is not dead. White supremacy is not dead. At least the FBI doesn't think it's dead at all. And so the question remains, what kind of tools can be used to augment our judicial system to fight things like the Klan? Well, let me just sum up, if I could, with, I'm sorry about that. So concluding observations. Well, we mentioned the fact that the ex parte Milligan case exists on the books, but is now used and has been used recently with the efforts by President George W. Bush to deal with terrorists. It's been used as a break on any effort to try have military commissions for what he called non or enemy combatants. But what does this whole thing tell us about Reconstruction and the impact on American society? Well, one, in many respects, there were great opportunities available during Reconstruction to create this multiracial, pluralistic democracy. Did it fail, or was it delayed? I think it was substantially delayed for at least another generation. But the architecture, the legal architecture of the 13th and 15th Amendments were in place. And in fact, in terms of the suffrage of women in the 19th Amendment, that was certainly a result of all the fine work that had been done during Reconstruction. But nevertheless, a whole generation, certainly of Black Americans, 100 years, in fact, had to wait for the dream of equality to actually be realized. The second is, I think, in general, there is an aversion on the part of American society to the use of the military as a domestic police force. In fact, in 1878, the Democratic Congress passed what has been called and is now known as the Posse Comitatus Act, which, in brief, restricts the president and the Congress from using the military as a domestic police force. The Democrats, certainly the Southern Democrats, wanted to make sure that the military occupation experience of Reconstruction would not be repeated. So that's my presentation on President Grant, and would welcome any questions you may have.
Wow. John Adams said that a moral people is the only type of people that can handle the U.S. Constitution. Don't you think the failure here of Reconstruction depended on an inadequate model of education between the two groups? In other words, Stonewall Jackson was willing to violate the laws of Virginia and teach the Bible to African-American slaves. So somehow I think there's a big problem here in the educational model that Adams was not listened to, that you can't, laws don't work if the people are uneducated.
Well, I think you're onto something in two respects. And number one, I mean, the problem with emancipation and Reconstruction is and I think I actually had a discussion with Abigail about this in terms of the serfs in Russia. You can't free 4 million people and say you're on your own. There had to be more, much more, in the way of support and education. That's one thing. The other part of it is, I think someone like Lincoln, and I go back even to his and Stan's experience during the Civil War when they suspended habeas corpus, instituted military tribunals. They did it because of emergent conditions, and they did it for a very limited period of time. And I think in a democracy such as ours, you have to be willing to go to draconian measures for very brief periods of time to protect what's really vital.
The claim of
Wait a
Abigail
minute, excuse me,
Adams.
Eric, do me a favor.
All
Eric,
right,
there are
I'll
a
mute.
lot of, there are a lot of people on tonight. They're gonna have questions. And let me just, before we go, I didn't have the opportunity to say what I normally say with the questions. One, it's unfortunately, I'm not gonna go into details, but what happened, do not mention, this topic is of 1865. It doesn't go beyond that. You can't equate it to today's topic. So keep your questions on that area. Number two, no more statement, no more, I apologize for that. No statements. We're here to hear the speaker and what he has to say. Keep your questions to tonight's topic. And you don't want to hear me say, stick to the topic, but work toward the topic. And try to take them, we'll have to take kind of questions one at a time because there are people on here. And unfortunately, when you do end, certain people are cut off. So please work one at a time.
Rich, do you want me to read the questions from the chat, or Jay?
Yeah,
do you
I think I
questions
prefer
from the
that.
chat?
Let's do that first. Yeah. And then
Yeah, Abigail, why
we'll
don't
see
you
where
read
we're-
the questions? I'm just going through them now, but go ahead.
Okay, there's one from Eric Braverman, but I think he just spoke, so we'll pass that one by. So Bobby Francis asks, how much do you think that the schism in the abolitionist/women's rights movement, the American Equal Rights Association, over the 15th Amendment, black male suffrage but not universal suffrage, was a factor in helping the South win politically what it could not win on the battlefield? If women had been added to the electorate then, how
Wait a
much?
minute, Abigail, again, I realize you're reading it, but again, it got to be a question.
Well, the question's coming.
Yeah, but no, but let's,
I'm just reading what's there, and
edit it, edit it.
Bobby, whoever it is giving some background. Okay, so the question is, if women had been added to the electorate then, how much difference would it have made?
Pardon
The
if I
short
may,
answer
my first part was the question. I wondered what his opinion was of that factor in 1869.
I can tell you that there was enormous discussion about actually women's suffrage under the 14th Amendment before we even got to the 15th Amendment. And there was a lot of, disappointment that the Congress, did not consider, female suffrage during this time period. I never saw in any of the research that I've done that issue of women's suffrage was peculiarly anything that the South was concerned about. If anything, the South was concerned about restricting suffrage, not only as to blacks, but as to Republicans and non-landowners. So I don't see that as a factor in their analysis. And I'll just say, there's a recent, for your edification, there's a recent biography of Woodrow Wilson that you've got to look at, because here was a progressive from New Jersey who, even though women had the right to vote, was very much against women's suffrage, even within his own family. And the importance of Wilson, of course, is that he is your quintessential Southerner who grew up in the Civil War.
Okay, next question is again from Eric Braverman. Stonewall Jackson taught Bible study to African Americans. Why was education not the focus of the Reconstruction effort?
Well, I just would say that the Freedmen's Bureau, the social welfare agency that I mentioned that was created, did fund and operate a lot of schools. but that was the that and land redistribution was the focus of the Freedmen's Bureau. But that's the only, other than church groups and volunteers who were engaged in the educational effort.
Okay, Jim Lynch wants to know, was there any discussion of giving or selling land to the freed slaves?
There was, and the term 40 acres and a mule was a promise that was, at least many blacks believe, had been made. But despite the efforts, they never really got around to any kind of real land distribution. There were particular experiments on dividing plantations up in coastal South Carolina to give plots of land to freed slaves, but it didn't go very far at all.
Okay, Ryan Green is currently doing research on genealogy in South Carolina, Chesterfield and Lancaster. Do you know where he can find any testimony of the local people to federal authorities regarding the Klan?
Yes, that report that I mentioned of the Joint Select Committee has, published 8 volumes, and you can sort of go through them the same way that you could go through the committee records on the conduct of the war. One thing that I did not show is sort of a select bibliography, but there's a recent book out, came out last year, 2023, by Fergus Berdovich, who is written on Grant and the Ku Klux Klan War, and he relies for many of his quotations on testimony before that joint select committee that I mentioned, and you might find some helpful references there to those particular counties in South Carolina.
Okay, Ryan Green also is asking, had Senator Charles Sumner, Republican of Massachusetts, lived longer, he died in 1874, do you think he could have continued the fight for voting rights? The only person past 1876 who seriously tried was Henry Cabot Lodge Sr. in 1890 with the Force Bill.
Yeah, it's speculative. I was surprised in my reading that Sumner isolated himself so much in the Senate, and the Civil Rights Bill of 1875 was basically his work, but he went to war with Grant over the treatment of the South, and joined Schurz and Lyman Trumbull in opposing Grant as a Republican. So given that division, I don't know what he would have been able to do more in the way of voting rights.
Okay. Excuse me. Edward Flanagan wants to know whatever happened to Attorney General Amos Ackerman.
Interesting question. He lasted only a year under Grant, and he's replaced by another George Williams. And Ackerman, there's always a question as to why he in effect resigned, whether he was asked by Grant to resign or not. Apparently there was some problem with Ackerman and some of the railroad barons that created some political difficulty for Grant, and I think it was agreed that Ackerman would resign, and then he later went into or continued in private practice and never got into government again. But he's kind of a hero of this whole war against the Klan.
Okay, Molly Craddock is asking if there was an area of the South that the freed slaves particularly prospered in, and if so, why?
The answer is I don't know, but I do recall, and this is the only example I can give, but there's a book out by about the Port Royal experiment in Port Royal, South Carolina, in the lowlands. And it was actually a group of New England educators who went down and worked with a group of freed blacks off a particular plantation. And the experiment was on this land redistribution that I spoke about before. And that's the only sort of example of what I would call really supported development and activity for freed blacks that was partially successful. There's also a lot of work that's been done on the Freedmen's Bureau and its successes, although pretty local, and that's all I could do is refer you to that.
Okay, another question from Tom Hildner. What is the legal authority for the creation of military tribunals? Can they be used other than during the time of war?
The legal justification, comes out of the president as commander-in-chief and his authority. And the as to when they can be used, that's an interesting question because it usually, I mean, as I mentioned, President George Bush in following the 2001 World Trade Center attacks asked for authority to use military force in combating enemy non-combatants, the terrorists, and he got it from Congress. So, was it a declaration of war? It would probably certainly fall within the definition of wartime. But that's where I would look for the authority.
Well, let me
so-
pop in for 2 seconds on this one. Tom Hildner has been one of the presenters for years, also on our legal panel. And next month in January, whatever the fourth Thursday is, he'll be doing an analysis. That's our program, an analysis of Lincoln's July 4th speech before Congress. And it's going to be, I think it'll be an interesting program. And I'll be the moderator on that program as he does his analysis. Notice how I worked in a commercial right in the middle.
And speaking of Tom, he has another question. What was the authority of the Freedmen's Bureau, if any, to resolve disputes between freed slaves and their former owners, who became their employers in many instances?
The authority would have been, I think, certainly at the beginning, the Civil Rights Act of 1866, which was passed the same time as the Freedmen's Act, which was supposed to level the playing field within the local courts and gave rights to testify, to own property, to enter into contracts, and so forth.
Okay, Lieutenant Colonel Kenneth Kata wants to know, was the Klan involved with the agreement between the Southern Democrats and the Republicans in the election of Rutherford Hayes in 1876 and the withdrawal of federal troops in the South?
Well, not directly. I mean, when I mentioned that Grant had sort of broken the back of the Klan, that was in the 1872-73 time period. So the Klan went back underground. But as I mentioned, they're not far from the surface. So I'm sure they had, some role. Clearly, the Klan did not want the military, U.S. military in the South, and would be expected to fight against any continued military presence.
Okay, that seems to be all the questions in the chat. There's a lot of positive comments, which I won't read, but I can send you the transcript afterwards. Oh, another question appeared. Okay, from William Miller. Putting sectional differences aside, do you believe that slavery would have come to natural termination with advances in industrialization by the future date, like maybe 1900?
Again, that's very speculative. I've always been interested in that issue of whether slavery would have died of its own weight. It continued in Brazil, for example, into the 1890s. And I'll tell you, it goes further because there were efforts, as everyone probably knows, to use slaves in industry within Richmond, for example, at the ironworks. There was efforts to use slaves as agricultural workers, not on plantations. And those who have, studied the issue of the profitability of slavery and so forth have concluded it was not a profitable enterprise. And so from their thinking, if you don't have a plantation economy, you're no longer going to have slavery. But that's most I could say.
I'll add on two things. One, there was a Pulitzer Prize winning book a number of years ago, Slavery by Any Other Name, where they were just arresting people on debts and sentencing them to work in various factories through that. That's again, I should have mentioned that. There's a what if questions, and you really can't answer on these questions here.
Well, there's one more question that just popped up from Ryan.
Okay, last question, and then I'll end the meeting.
Last
Go ahead.
question. What was the federal government or grant's response to the Hamburg massacre in South Carolina in 1876?
I'm afraid I
I
don't
can't hear.
know the answer to that by that point. I do know that, based on the one in Louisiana, that the federal government did not want to get involved in responding, certainly in any preemptive way, to any of these racial riots that had happened. And that was as of 1873. So I don't know that it would have changed by 1876, but I really don't know.
Yeah, I pretty much know the answer. Actually, they didn't really get involved until they passed the recent Civil Rights Act, where they couldn't get involved. The federal government just let these murders continued. In any event, Jay, that's a great presentation. Really appreciate it. The scholarly work involved in it. That's our meeting for the end of the year. We'll resume our book group. That again, our members only book group based on the second Thursday of January, and on the fourth Thursday, Tom Hildner is going to do the analysis of that. And I just want to wish everybody a Merry Christmas. Thanksgiving's coming up next week, and a New Year. And again, thank you, and I hope you will join us again. And by the way, my final line, if you can get your library to participate in this, please, any library anywhere can get our programs, and we'll send you what our program is in 2 weeks.
I'm on the program because I work at the library in Hackettstown, New Jersey. So that's where I got the information and the login.
Okay, get that out of whatever town you live in. It's more effective if the individual goes in. When I call up the library, I think I'm selling car warranties. But if you go in and say, "Hey, I'm a taxpayer, get me in," then they listen to you.
Hey, Rich, there's also Washington Crossing Day on December 25th or 6th down where
and they have on the 8th or 9th, they have the rehearsal, which is even better than that, because you go into Pennsylvania and you watch your troops.
And don't forget, Jesus celebrates Hanukkah in the Gospel of John, chapter 10.
All right.
So
all right. Let me end this tonight. Again, thank you for attending, and we will say good night.
Good night.
Thank you.
Good night, everyone.